Hello and welcome to the Bellevue Brief, a podcast from the team at Bellevue Law, providing insights into topical workplace law and commercial disputes issues. I'm Florence Brocklesby, the founder of Bellevue Law, and I'm joined by my wonderful colleague Georgina Calvert-Leen, senior consultant at Bellevue Law and employment and equalities lawyer. Hello, Georgina.
Hello, good morning.
And today we're going to be talking about the impact, 1 year on, of the Worker Protection Act, which created a positive duty on employers to take reasonable steps to prevent workplace sexual harassment. It's known as the preventative duty. We're going to talk about what change we've seen as a result of the preventative duty, what further change is likely to be coming when the new Employment Rights Bill becomes law, and what approach employers should be taking to prevent sexual harassment at work and to deal with allegations when they arise. So, Georgina, as a reminder, the Worker Protection Act came into force in October 2024. Can you provide us with a recap of what it does?
Well, it provides for the first time that employers have to take positive steps to try to prevent their employees from being subjected to sexual harassment in the course of their work. And it does have some teeth because if an employer hasn't taken the sort of steps that the statute expects them to take, then if they're then subsequently sued by one of their employees for harassment and the employee is awarded damages, those damages can be increased by up to 25% if a tribunal were to find that the employer had also breached their duty, their positive duty to prevent sexual harassment. So that's one important way in which employers can be sanctioned for non-compliance. Also, the EHRC has got enforcement powers, and those include things like mounting an investigation into whether the employer is complying with this duty, and they can issue unlawful act notices and injunctions. They can require employers to do specific things.
And there's some quite significant reputational risk for employers who are subject to enforcement action from the EHRC.
Yes, for sure, because the EHRC is always keen to show the world that they're doing their job, and so they do publicise these investigations and notices.
And taking a step back then, the context for the legislation is very widespread prevalence of sexual harassment, and it impacts quite a significant proportion of the population, predominantly but not exclusively women.
Yes, I mean, it's a sad reflection on life that things have not changed significantly, even over the past 7 years. So, I mean, after Me Too, many people were hoping there would be a whole sea change. And there has been changes in reporting and in some things, so I don't want to minimise it. But statistics suggest that there has not been a huge difference in the part of the population that has been harassed. So, for instance, the House of Commons Women's and Equalities Committee commissioned a survey in 2018 which showed that about half of women had had experienced sexual harassment in 2018, and men about 18 to 20%, so men also, but at a lower number. Roll on 7 years, and Unite, the union, commissioned a survey conducted a survey of their female members, and they find that even now, in 2025, it came out sort of very recently, it's about 54%, I think it was, of women, of those participants, said that they had experienced sexual harassment, and of those, 25% had experienced sexual assault.
That's quite a shocking statistic, actually.
It is incredibly shocking.
Yeah. And I think that's probably representative of sexual misbehaviour in wider society.
Yes.
We were talking earlier about the College of Policing report, which described an epidemic of violence against women and girls, and said that maybe 1 in 20 of the population is a perpetrator annually. And that's something I've reflected on doing the kind of work that we do. Employers can feel that there is a stigma around complaints of sexual harassment being made in their workplace. I wonder if recognising how prevalent misconduct is could be a key to addressing it. Instead of thinking something terrible must be happening in our workplace if this kind of complaint is made, employers should be thinking, well, this could happen here. Any
Yes.
employer of any size whatsoever is likely to have a number of employees who may well have the propensity to misbehave in that way. And therefore, it's not a sign of a bad workplace culture, but in fact, it's a sign of being realistic, that you're taking the steps to address it, that now this legislation requires. And it might be more concerning to be an employer with no reports of sexual harassment than an employer who does receive reports and is open about addressing them.
Yes, I think that's absolutely right. That especially if you're a large employer, it would look somewhat suspect if you have a supposed clean bill of health. It looks a lot more realistic to have had some complaints or disclosures and to show that you have acted on those.
So, Georgina, 1 year on, what have we been seeing in our practice and more widely as a result of this new preventative duty?
Well, we can't yet point to any employment tribunal decisions where an uplift in damages has been awarded because an employer has failed to take the steps required under this preventative duty. It's too early.
And that's perhaps not surprising because there are quite big backlogs now in the employment tribunals.
True.
So any claim that was brought after this law came into force is unlikely to have made its way all the way to a final hearing yet.
Yes. That's not to say that they haven't been added. I mean, I've had a number of cases where a failure to comply with this duty has been added. And I would have thought nowadays most complainants who are bringing a harassment claim will give good thought to that, because if they've been harassed, something has happened. It may be the employer could not possibly have prevented it. But usually there are circumstances which would suggest an employer might have done more. So I would have thought most complainants will add that as an extra claim. Anyway, too early to see changes there. The EHRC has been flexing its muscles and has issued some notices, but not specifically about breach of this duty. Well, possibly, but also about conduct that happened before this duty came into force, before the requirement to prevent sexual harassment.
And a reminder.
A reminder,
of
there's... yes, a reminder, exactly. And so there's been well-publicised warning notices issued to McDonald's and to Lidl. But I think what's really interesting is to look at some stats around what has happened. So ACAS, I think it was Erwin Mitchell, made a Freedom of Information request to ACAS to see whether they had had any increased inquiries about sexual harassment. And they were comparing 2024, so it was almost in anticipation of the duty that would come into effect or be required from October. So they were comparing, I think it was the third quarter of 2024 with a similar period in 2023. And there did seem to be a huge increase, sort of more than 100% increase in calls to ACAS about harassment and sexual harassment.
And the theory there being that increased awareness of people's rights in the context of sexual harassment at work because of the implementation of the legislation had given rise to increased calls to ACAS and potentially down the line increased claims.
Yes.
And that's probably then validated by another Freedom of Information request by another law firm, not us, a firm called Knockolds, which made another Freedom of Information request a little bit later to ACAS and found a 39% increase in calls about sexual harassment in the first 6 months of 2025 versus the same period the previous year. So there's definitely something going on that is making more people pick up the phone to ACAS to discuss this issue, whether it's increased awareness or increased rights that people are looking to enforce.
Yes. I mean, it's clearly having some effect, probably early indications of an effect. And there was another survey done that was reported on quite recently in Personnel Today. And it was a WorkNest survey that was asking employers, so looking at a different angle, asking employers, how do you feel about your compliance with the Act 1 year on? And about half of them said, we don't feel good. We don't feel we've done enough to comply. And actually a more specific percentage or stat was 41% said they hadn't even done a risk assessment, which is a key foundational part of complying with this duty. So it seems like employers have got some catch up to do even now.
So that leads us in, Georgina, to asking, what should employers be doing? What hopefully have employers been doing, and what should they be doing to comply with this duty? And the starting point for that is almost always going to be the risk assessment, isn't it?
Yes, absolutely. What employers should do will depend largely on their resources and their size. So there's no one size fits all list of things that you can point to say what employers should do. But certainly everyone should do a risk assessment, and that will look at their particular circumstances, or the circumstances in which their workforce works. So do they work on their own, for instance? Do they travel? Do they travel with colleagues? What's the demographic range of their workforce? Who holds the power? Do they have many one-on-one meetings? Another risk may be alcohol. I mean, is alcohol involved in client development things? Is it are there many office parties or bonding episodes where things might go awry? And so every employer will have a different set of circumstances, and their risk assessment ought to record that and think about, well, how can they mitigate those risks? Yeah. So doing a risk assessment, as you say, it's foundational, must be done. Looking at your policy is an early thing that every employer should do. And a good and robust policy would define what sexual harassment is, give a few examples, because that's not always clear. Sexual harassment's not the same as sexual assault. Sexual assault is certainly sexual harassment, but there are other things that are also sexual harassment. It should say what sanctions or what steps might be taken if someone reports it. It should say who you should report it to. I mean, some big organisations will have a couple of dedicated, possibly champions, DEI champions, or they could be called anything. And also employees need to be able to go to someone they know. So there ought to be various different reporting lines. And some employers may want to introduce an anonymous reporting line, like a helpline, so that people can report something that they don't really, or perhaps they've observed it. It may be a bystander. And they may not be ready to make a formal complaint anyway. So after you've got your policy, after you've done your risk assessment, there's no point having a good policy if you don't communicate it to your workforce. So you need to communicate the policy. In fact, you may have consulted the workforce in developing your policy. You also need to train your workforce, but you need to train also the managers who may be receiving disclosures or reports of sexual harassment, so they know what to do. And then the managers need to know, well, what do they do with it next? So you need to have a very robust complaints procedure, which will include an investigation. Sometimes the investigation it will be more appropriate to get an external person in, a sort of an expert in conducting investigations in to do it. And that may be especially appropriate if it's a very senior person who's accused of sexual harassment.
Or very serious allegations.
Or very serious allegations, for sure. And then another thing, which is quite new, I think, but employers can and should keep records of complaints that have been made historically. They should not think, well, because of GDPR, we should necessarily cull every disclosure or report sort of very routinely or after it's dealt with. The duty is quite clear that the duty is one that is meant to be reflective, and you can't be reflective and improve your culture unless you keep a record, because it may be that multiple people have made disclosures of sexual harassment without wanting to put their name to it, without making a formal report. And unless you keep records, you cannot then identify whether there are trends within certain departments where perhaps you need to put in more training, or you need to adjust how people work in order to mitigate the risk of sexual harassment happening. So that monitoring and recording is a really important new step.
So it's a duty to take reasonable steps to prevent sexual harassment, and that means to consider and act upon the information you have about patterns and trends within the organisation.
Yes.
And something which I think has been touched upon in a number of sector-specific reports. I'm thinking about the very recent report by Baroness Harriet Harman, KC, about the bar. I'm thinking about last year's Sexism in the City report from the House of Commons Treasury Committee. Is the paramount importance of culture in these kind of conversations. Because all of the risk assessments and policies and training in the world won't really get to the root of this problem without a determination from the top to deal with it appropriately and properly. And Harriet Harman called for a reset of culture. And there was a quote that she included in the report from somebody who had given evidence to her saying, everyone knows, but nothing is done and nothing will change. And it's the nothing is done that has to change if these kind of statistics that we were talking about of the prevalence of sexual harassment in the workplace are going to change. So that culture just needs to be set from the top.
Yes, absolutely right. It's no good having a perfect policy and having a very diligent HR department if people know that it's not going to be enforced against everyone.
And that sometimes there's some jeopardy for being the person who reported.
Yes.
As well. That's the idea that reporting will make a bad situation worse is quite widespread in certain sectors or certain businesses. There needs to be a determination from the top of organisations that reports will be dealt with in good faith, and a thorough and appropriate investigation, I think, is
Yes.
the key to that, isn't it, when reports are made. Georgina, that's a really helpful summary of the changes that have already come into force under the Worker Protection Act, the preventative duty. There are other changes coming down the line with the Employment Rights Bill. We're having this discussion in the middle of October 2025. We're anticipating that the Employment Rights Bill will become law shortly. And there are a number of provisions in that legislation that are also relevant to any discussion about workplace sexual harassment.
Yes. Yes. Well, a big change is that the current law says that employers have to take reasonable steps, as you've said a number of times. The change is just adding the word all, but that's quite significant. So going forward, when this change comes into effect, employers will have to take all reasonable steps to prevent sexual harassment, which does seem to raise the bar quite high. And they're certainly going to have very robust risk assessments and monitoring and evaluating of the risks so that they can show that they have taken all reasonable steps rather than just some.
So those 41% of employers who haven't yet done a risk assessment, the first thing that they need to do is to sit down and think in quite a granular way about what the real risks are in their business, and then take the steps they need to take in order to address them.
Yes, and record what steps they've taken, because that's how they're ultimately going to have to demonstrate that they've done it if they ever have to prove it. Now, in addition to that, there's the NDA, and the Employment Rights Bill is going to not completely prohibit, but very much restrict the use of NDAs. So if in the past employers' modus operandi has been they receive a sexual harassment complaint, they think, oh dear, this is going to look very bad for the organisation, they hush it up, perhaps they get rid of the person accused, they dismiss them under a settlement agreement. They may also ask the person who's made the complaint to leave, give them a settlement agreement, pay them off, with the supposed luxury of having an NDA or a confidentiality clause within the settlement agreement so that no one talks about this again. That's largely not going to be possible any longer. And I think that's probably a welcome step, because the danger of an overuse of NDAs is that things are swept under the carpet rather than culture being addressed or poor behaviour being addressed head on and dealt with through training or just a change of culture.
But it's quite a seismic change because often, I mean, I would say in my experience generally, where an individual makes a complaint of sexual harassment at work and then in connection with that they leave the business, not necessarily because they're forced to leave, but perhaps they're not happy to remain after what has happened. There will usually be a settlement agreement, and that will almost as standard contain what we call an NDA, contain confidentiality provisions relating to the circumstances leading to the termination of that employee's employment. And the Employment Rights Bill now contains provisions saying that in cases where allegations have been made of discrimination or harassment, such a provision would be void. And what that means is where you settled a potential claim as an employer, you won't get the additional comfort of knowing that the exiting employee, to a large extent, with some carve-outs, is unable to then go ahead and talk about what has happened to them.
Mm.
And it remains to be seen what the implications of that will be in the workplace. There's some controversy about it. But I think it's certainly the case that employers will now need to expect that their investigations and their processes and their culture will come under increased scrutiny where they have one or maybe several incidents of people complaining about this kind of misconduct at work.
Yes, absolutely. So it all dovetails, doesn't it? I mean, really, an employer needs to show that they have been proactive in trying to prevent sexual harassment, and then when it has arisen, and we were talking about how we're coming back to it not being an immediate stigma to have had these sort of complaints, because statistically you're likely to have some if you're a large employer. But the important thing is to expect that however you behave as the employer, you'll be subject to scrutiny. So you do need to get on with complying with your duty to try to prevent sexual harassment. It may not always be possible, but you need to be able to show that you've tried.
And that when allegations might be made, that in good faith you have conducted a reasonable investigation to address those allegations.
Yes.
And in individual cases, that may still mean that people who've made those complaints may move on for whatever reason. But the theory, at least behind this reform, is that it will lead to cultural change in a way that settling individual cases just hasn't done.
Mm. Yes, we can see from the statistics of continuing sexual harassment that what has been happening in the past has not worked enough, not sufficiently to change culture.
Yeah. So overall, we're talking about a picture where the legislation that's in force already and the legislation that's coming means there is going to be more focus on harassment, on sexual harassment, and a need for employers to proactively take those steps to address it in advance, and then when allegations are made, not to shy away from dealing with them in good faith and putting in place sensible investigations to address the underlying issues.
Yes.
Well, thanks, Georgina. That's been an absolutely fascinating discussion on a really important topic. We'll link to the resources that we've discussed in the blog post that accompanies this podcast on our website. And thank you to the listeners for joining us for this episode of the Bellevue Brief.